who are former, oh, did I start too early?
No, I think if you just
Now this needs to.
got it, yeah.
Okay, now that we are recording, I will record my thank yous again to David and Warren for hosting me. And the two abbreviations that you see there is just what I started to talk about, because there were some flags there, the Ukrainian flag and the Afghani flag, because the last time I presented, the Taliban takeover of Afghanistan was very much happening, and I felt it very challenging to present this research because I had just received an email from a former student who had been at the airport in Afghanistan, and one of those famous images that was on screen with the people trying to make it on some of the flights out. And it was really heartening, of course, to hear that he had made it, but it was still tough to be talking about a topic such as this. And the same, of course, goes now in the middle of the Ukrainian conflict. And what I will be talking about is, I think, much more regulated and much more the regular process. But I think that is also part of the problem when we're talking about discussing vulnerability in the migration context. So I wanted to talk to you a little bit about the EU-funded research project that I'm currently a part of. It's called Vulnerabilities Under the Global Protection Regime, the so-called Vulner Project. I'll just tell you a little bit about the countries that are involved. And Canada, interestingly enough, is one of the participating countries, which is always interesting in terms of who the comparison is, where we're trying to achieve, in this case, policy and legal change. And what is really fundamentally interesting is that if you're familiar with migration work and you think about refugees, you think, well, isn't every refugee inherently vulnerable? And that is precisely conceptually what is part of the discussion and the problem. But the trend that I want to talk about is that vulnerability as a concept is currently quite hip. It keeps occurring and it increasingly is getting codified. And it seems to be the standard that countries also use to sort people between deserved and not so deserved. And that's what we need to, I think for a few minutes about. And Canada, as some of you may know, although I'm very aware that I'm presenting in the other country in North America, is considered to be a leader when it comes to refugee protection. When the Americans were slacking off recently on the resettlement front, Canada recently became the top resettlement country. Of course, if the US is stepping up its efforts again now, Canada will be dropping quantitatively again. But there is a reason why it might be interesting to look at Canada in a comparative context, just to see what best practices might be when it comes to deciding who a vulnerable migrant is and what policy consequences there should be, depending on how that label is constructed and how you then proceed in terms of who gets in, what the consequences are. In the particular example that I want to talk about today, I want to contrast the two different worlds of vulnerability when it comes to the overseas resettlement process in Canada and the inland asylum process. And again, because I know I'm speaking to a US audience, in Canada, there basically is only one inland process if you make it into the inland process. I'll show you a little bit of the details, but I'll be fairly light on that because I really want to highlight the contrast between the world of resettlement and the world of the inland asylum process, because that really is conceptually something where we can also ask normative questions about, should there be differences in the way that we select people overseas and that we give preference to somebody perhaps in a hearing when they have made it to the country and when we're asking them questions about their story of flight and their story of persecution. And I also need to say from the outset that because this is an EU-funded research project, that we're very much working in the world of, we have EU policymakers listening who we're writing and reporting to. And in Canada, we're also asked and required to hold policy workshops with decision makers. So this is very much we're trying to have our foot in the door and we're trying to actually make change. So I will talk a little bit, of course, about the critical literature, but the question is, does an EU bureaucrat care about the theory of vulnerability? Can we get them interested? So there's a bigger academic conversation, of course, about securitization, about extraterritorialization, about all the stuff that you see on TV that's not represented in some of the bureaucratic steps that I will be talking about. But that, of course, one could argue is also the problem, because you're keeping a certain type of vulnerable migrant at bay, because they're not even getting close to some of the procedures that I will be talking about. So the Vulner Project is a 3-year Horizon 2020 project. And again, what's exciting from the Canadian perspective is that it's funded by the Canadian government as well. So that's SSHRC. And because we have a colleague from Quebec, it's also covered by the Quebec funding agency, aside from some European countries. And notice that it's not the EU because Norway is part of the team. We have researchers in Uganda and South Africa, actually a colleague who's based in Germany. We have a team in the Middle East. And in Canada, we actually have 1, 2, 3, 4, 5, technically 6 universities. At York, where I'm based, I have 2 graduate students, and one of the graduate students, we just have a paper that got accepted that's forthcoming. That's Melissa Anderson. So some of the research is also something that she has been thinking about very hard. So the Vulner Project was conceived before COVID. And of course, that raises a whole bunch of questions that exasperates vulnerability, but that needs to, of course, be said from the outset that we had a really hard time trying to figure out how to deal with the original idea. And the original idea is on the left, that there's a growing international interest in protection of vulnerable migrants. And please note the quotation mark, because again, the definition is what we need to talk about. It was enshrined in the global compact that states are now committing to the protection of vulnerable migrants. But really, it's very unclear what the decision-making process is at the bureaucratic level, what the bureaucrats and judges also are basing their decision-making on when they label somebody as vulnerable, and what then the consequences are. We are doing interviews with government officials. We're also talking to judges, depending on what the different countries are. We're also going to be talking to migrants themselves. And that's still going on in the Canadian case. In some of the EU countries, they've already done quite a bit of field work. The Lebanese team has also been to refugee camps. So there's quite a variety of voices coming to the table, but that's precisely what we're interested in finding out about. How do people at the top decision-making level understand and conceptualize vulnerability, and how are migrants experiencing that, and where's the gap, and then what recommendations can we really make? And what, normatively speaking, do you imagine how somebody should be treated? And that's where the comparative insights are also, I think, really interesting, because it's already emerging that the European colleagues seem to like checklists of vulnerability, and UNHCR likes the checklists. That's something that's not very practiced in the Canadian case, but that's already been interesting to find out about. But something that we're concerned with really is that there seems to be a contest of vulnerability. Some vulnerabilities are valued more than others. And in some contexts, especially in the legal context, it also seems to be that some vulnerabilities then get normalized. Oh, wow, you're a woman, and well, but you're not low income in Cuba, so therefore you do not get procedural accommodations X, Y, and Z. So that is something that also is happening quite unevenly, that some vulnerabilities are taken for granted. And that is also something that you can also find in the case law. And that is really a fundamental concern, because that can also then lead to what some people have called a humanitarian fatigue. I see that there's a point in the chat. I don't know if anybody else can check that, or if only I can check it. So I don't know if somebody's saying, I can't hear you. Okay. Okay, nothing to worry about, I think. We're totally good. But ultimately, again, the project is about policy change and making recommendations. So now I clicked somewhere else and I can't advance. Uh-oh, hold on. There, okay. So I have to, of course, do the promo. we had some publications that came out. There is longish stuff that you can read if you're interested. Each country published a country report. That's the thing on the right. That's Canada, cutting the US off from the map. And then there is a more conceptual note that the PI in Germany, Luc Leboeuf, has written. That's the thing in the middle. That's, I think, quite interesting also from a theoretical perspective. And then we have to write these short few-page policy briefs that are really struggling and difficult for us academics to write, just to be a bit punchier about what we think should be the recommendation at the first phase of the project. And the first phase of the project for us was really in Canada, looking through a huge body of case law and administrative regulations. That was, I think, absolutely crazy, but in some sense, it's also really interesting that there have been so many different mentions of the word vulnerability. Sometimes it's called special need, sometimes it's special protection. But overall, the problem seems to be that everybody thinks they know a vulnerable migrant when they hear the word vulnerable. That's also represented in the interviews where people have trouble defining what it actually is, but they immediately give you an example of a situation. But again, conceptualizing it is really a problem. And it comes back to, well, I see a vulnerable, I can't say this in English properly. I know a vulnerable migrant when I see one. This is again the promo. I'm happy to share the slides. One of the papers, we have a special issue coming out for the Canadian papers, is already accepted and is out. Ours just got accepted and will be out soon, but there is more on this if you're interested. But now let's talk a little bit about vulnerability, and there's a big theoretical literature here. If you have take a moment and think about, well, what do I think vulnerability is? Then most people say, well, there's something innate. It's that you're a woman, that you're a child, so that there are these innate markers where some people get labeled as vulnerable or what inherently makes them vulnerable. But then there are a lot of situational circumstances where somebody might become vulnerable. And that is quite different because they're a certain group, because they have a certain sexuality, because they're currently experiencing a death threat, or they're under threat of being arrested because perhaps of their political opinion, or because of their ethnicity. It might be also because there is a famine or some environmental disaster. So we have quite a few different circumstances. But what's interesting in some of the law is that the innate characteristics often get prioritized over some of the situational markers that are on the little bubbly screen that you see. And there's a big discussion in the theoretical literature about how we should understand this, what the pros and cons are of conceptualizing it in terms of innate markers. And the argument is, no, we should be moving to situational assessments, but how does that really look like? And I'm happy to share some of the theoretical references, since I know I have a legal theory person in the room who might be interested in this in particular. There's also, of course, a struggle of even using the word vulnerability. Some people prefer precariousness because vulnerability can be quite pejorative. In interviews with NGOs, we've been finding that people say, well, I prefer to characterize somebody as at risk. If you talk to migrants themselves, they understand at risk, but for them, vulnerability is also something that they really have a hard time linguistically getting their head wrapped around. So if you talk about trauma, that can be physical, but it can also be mental. And that then leads to, as you'll see in a few minutes, to different policy consequences. But what it is fundamentally is that vulnerability is not about self-reliance, but there is, as some of you may know, a strong literature at the moment that talks about resilience. So there is an interesting tension between this focus on groups that are at risk and still presenting migrants as having agency and being able to build their own lives. So that is also an interesting tension that we find in some of the theoretical discussions. Again, I want to just emphasize, because I find this quite problematic and I don't really have an answer yet, that there seems to be this contest of who gets in the door first. How should we prioritize. If you put a bunch of markers over there in the left, and that could be what you put in the regulation, in the UNHCR handbook, in the policy guidelines, well, somebody will come out first, and that is for some people problematic. For other people, they say, well, that's a good thing because we're protecting the people that are most at need. But there is something else that's happening in that most at need process, and that again is this normalization of vulnerability that I've talked about at the beginning. So that's just a concern that I think we have in the project overall with some of the regulations. Just to remind you that we in the project, in particular in Canada, are not just talking about refugees, because that's also something that's emerging as an interesting conversation with the European colleagues, is that for them, if you talk about vulnerability, you talk very much exclusively about refugees. And since I know when I've given this talk before, not everybody's as familiar with the definition. So let me just emphasize that according to the 1951 Geneva Convention, a refugee is somebody who's been forced to flee. And then the reasons are persecution, war, or violence, but they have to be outside of their country of origin. And they have to be not willing to return to that country because they're really fearing for their lives. That's this well-founded fear of persecution. Some of you may know that there are 5 official grounds in the convention. Then there is this particular social group. That's the one that gets expanded. That's how gender comes in. That's how sexual orientation comes in. But this is not the easiest to meet because it's an individual, as most of you know, Second World War definition. So in the Canadian context, vulnerability also occurs for victims of human trafficking. They can, for example, get a temporary visa, but many of the human trafficking victims might not qualify under these criteria. Canada also has something in the context of if a woman, for example, comes with her husband as a sponsored family member, and in that process, at some point, there's violence in the family, she can get a separate visa because she's considered vulnerable. So there are some examples in Canadian law where we're talking about vulnerability outside of the refugee context. But for the rest of the presentation, I'll largely talk about the 2 overseas and inland refugee streams, but this is again already interesting in a comparative context that there are examples in law in Canada that are not just about refugees. And also about migrant farm workers. I could go on if you're interested later. So this is just, again, if you're American, there is a similarity. I was totally trying to brush up on my American Canadian context. So remember, there are these 2 different worlds in countries like Canada, Australia, New Zealand, the United States, where we have a long tradition of bringing in people as refugees from abroad. But we also, of course, under the 1951 Geneva Convention, accept people in Canada. There are a bunch of different actors, and I see that one of my little US flags did not come up on the screen. But Canada, as some of you may know, has a private sponsorship scheme where private individuals are allowed to name people who can then be brought to Canada, and a government-sponsored stream. So there are a bunch of the abbreviations on there. But the discussion about vulnerability mainly comes into the government assessment. Those are the rules that we've looked at, because for private sponsorship, it's up to the private sponsor to say, yes, we want to sponsor a woman at risk, or we want to sponsor somebody with a particular health profile and bring them to Canada. But again, in terms of what's enshrined in law, we looked at the government regulations. And there's a UNHCR interview, just like there is in the United States, but there are different actors of the government. There's Immigration, Refugee and Citizenship Canada that decides the overseas side of things. And on the inland claim, it's the Immigration and Refugee Board, that's a quasi-judicial board, that decides who gets in on this side of the screen. There is the Safe Third Country Agreement, and I don't know why there's a U there, because there was an American flag in my screen there, because some of you may know that Canada and the United States have an agreement. If somebody arrives in the United States first, then wants to go to Canada to claim asylum, most of the time they will not be eligible to do so, there are some exceptions. So that is where the geopolitically privileged position of the United States and Canada also is related and interlinked. And Canada benefits very much from this agreement because there are more refugees who come to the United States first and then want to move to Canada and then may potentially be sent back if they follow the official pathway. But again, we have two very different worlds when it comes to refugee and asylum. There are historic reasons for that, but the question is, should the criteria for assessing somebody who's vulnerable as they make their way through the bureaucracy, either overseas or in this case in Canada, but it could be the US or it could be the EU if there is a resettlement stream, should the criteria be different or should they be the same? Normally, these two streams don't even get talked about in the same policy papers because, again, they're different actors and they're different histories together. And the question is, can we justify different levels of transparency, different levels of discretion, and again, different criteria based on who might be overseas and who might have already made it? Is there a justification? So I wanted to give you an example of some of the rules, but I think I've already explained most of what is there. So I'm just going to skip this one because this is just my reminder that I've told you that we have these two different worlds. There are very different expectations in Canada, but there are also ethical questions to be asked. So I think I'll move on to the next one and just give you the examples. In Canada, in the world of the inland system, the question of vulnerability shows up very much in the so-called guidelines and regulations that are issued by the chairperson who runs the Immigration and Refugee Board. There are guidelines for children, for detention, for women. There is an explicit one for vulnerable persons that I'll talk about just to give you an example in a second. There's one for so-called SOGI claims, sexual orientation. Then there's also a new recommendation for how to deal with trauma and to have a trauma-informed hearing. So again, in terms of law and regulations and where vulnerability or similar words show up, they show up at the regulation and guideline level and not so much at the actual legislation level. The legislation level, there's only one mention, the word appears, and it's for the overseas process. For the overseas process, Canada, the United States, all other countries that participate in resettlements go back to the UNHCR Resettlement Handbook. Each country has a different chapter that outlines what the criteria are, what the different streams, the different priorities are. The United States has different regional priorities. Both countries, for example, have something that's called the Women at Risk Program. Canada also has something called the Urgent Protection Program, where somebody needs to be physically at risk. But that really is the main point where you can see the word vulnerability. Vulnerability gets equated with urgency, and urgency gets equated with physical threat. So if you think about the bubble from before, in terms of all the different ways in which one could potentially be vulnerable, the translation in the overseas handbook, the prime example, the urgent cases, is restricted to, in my opinion, that's a judgment call, to physical threat. That's understandable. In some of the conversations we've been having with overseas officers, they say, well, if I know that this person is going to be tortured or if this person is going to be arrested, that's a physical threat that's easy to determine. So yes, we will try to get that person out. In Canada has a 7-day trying to immediately get the person out. So I guess I understand why one wouldn't need this kind of thing in the inland process. But for the women at risk category, for example, that is a prioritizing, and there is some countries have a quota of how many people they will accept to take under this category, but there isn't an equivalent if we had time to delve into the details as to how women get prioritized overseas, as opposed to how a gender violence claim, for example, gets processed under the women refugee guidelines on the IRB side. So if we had lots of time to go into the detail, even for something that sounds quite parallel, there is a huge difference in terms of how quickly you get to the front of the line, to the resettlement stage in Canada and to the acceptance stage in the country. So these are just some of the examples of the regulations. But what's, I think, more important is that we need to talk about what you get if you get labeled vulnerable. And what you get in the inland process is much more restricted. It's restricted to procedural accommodation, and only very rarely does it lead to actually faster processing. So if you're a child, there's an explicit mention in the guideline for children that the claim should be assessed as quickly as possible. If you're labeled vulnerable in a detention context, then it might get you a faster and earlier review of the detention conditions. It does not mean that you'll get released. But the most important thing is that it gives you procedural accommodations. You would think that that really was something that everybody should get if you look at what those procedural accommodations are. And that is that you get a different order of questioning, you might get a different room, you might get a female judge. Those are all things where I would go, well, that shouldn't be that hard. It's also not that expensive. So there've been a lot of lobbying that procedural accommodations under the vulnerability guidelines in Canada really are tough criteria to meet. And a lot of lawyers are saying, well, I don't even ask for that anymore because it really doesn't do much. And that is, I think, surprising. And it's also something that I think we should talk about why that is so restricted. Because what it can get you, again, get quotation marks, I'm not sure if you can get my fingers, quotation marks, what it gets you in the overseas context is that you might have certain health restrictions waived, that you might have been excluded otherwise from even being considered for resettlement. So you might even get to be resettled, and you perhaps are eligible for this extremely fast emergency 7-day processing that gets you to Canada. Very interestingly, if you have particular special needs, there's also a way in which some services for you, resettlement services get arranged for you before you even leave the country and region of origin. Of course, if you look at some of the resettlement numbers and the overall population, that's still such a small drop in the bucket. But it's interesting that in the overseas context, there's so much attention to being paid to, if you have somebody with trauma, that there's trauma counseling available, that they go to the right community. So that's also very different compared to the inland process, where there is no equivalent to say, if you're labeled vulnerable, then yes, we'll get you this after we've accepted your claim, because that would be the equivalent. So it definitely seems that there is more attention being paid to vulnerability in the overseas context, just from my very quick presentation of this, compared to the inland process. But there's a downside, and I don't, yeah, okay, I think we will stay here for a second, but the downside is that the people that are making the decisions in the overseas context are provided with much more discretion, and there's much less oversight and transparency, because it's really hard to appeal the decisions from the decision makers overseas. There is a way to appeal them in Canada. The US process, as far as I understand it, you cannot even go to court. In the Canadian context, theoretically you could, but the problem is that nobody has money if they're in a refugee camp, might not have access to a lawyer, blah, blah, blah. So the few cases that there are cases from the private resettlement context. But to even get the decision and then writing and the actual criteria, you have a decision in many cases that can be reviewed on the inland side because it is written down. Sometimes it's not publicly released. There is an appeal board. So in terms of the steps, if the person got it wrong, there are way more steps, well, way more steps, yes, on the inland side compared to the overseas side. So that also seems a bit wonky, that more attention, it seems, is paid on the overseas side, but then it's so less transparent and there's so much more reliance on the training of the officers that they really get it right compared to the inland process. I think I've already kind of talked about this. This is just emphasizing in the inland process, if you're interested in the legal language, only the people that will be, who are considered severely impaired and who have difficulties that go beyond those that are common to most people appearing before the Immigration and Refugee Board, who would all be claiming refugee status. And again, the word particular difficulties, only they will be accommodated using this guideline. So there are some examples that are also in the guideline, but it's still kind of strange that it's this, everybody is vulnerable, and then some people, maybe they're more vulnerable. And that's, I guess, what we're struggling with in the project as to what to recommend. Obviously, it would be easier if this could be opened up, because there are probably many people that could benefit from more flexibility. So the question is, what's the downside? Does that really impair assessment of credibility? Is it really so much more expensive, right? Because those are often considerations. It's always about credibility and it's always about money. So just to get slowly to some of the questions that I would like to have you thinking about, there is a shared space of vulnerability. There are different, but sometimes similar individuals who happen to have made it to a global north country and who are asking for asylum. And then there are the many larger numbers of people overseas who are asking also for protection, and many of them we might consider vulnerable. And again, what that is in the Canadian context is very much physical safety and threats are prioritized. There are some other questions about, can you establish yourself in Canada? What are your alternatives in the country that you're currently in? In the inland process, what really gets highlighted is the severe impairment or perhaps the trauma. But should these worlds really be so dissimilar? What might the rationale be for bringing them closer together? And can we benefit from a conversation from overseas officers talking perhaps to IRB officers? And in Canada, that's a huge problem. They don't, I think, want to talk to each other very much, and there aren't very many channels to do so because of the independence of the IRB, even in some of the training sessions. But what are the downsides to having more of a conversation about this in the bureaucratic sense? Those are some of the questions that we have, because ultimately in both contexts, credibility is still assessed, although in the Canadian context overseas, it's not all about refugee protection. What's also interesting is that if you're interested in law and the courts, that the European partners are reporting that vulnerability is becoming increasingly judicialized. It's shown up at the European Court of Human Rights in a high-profile case that some of you may be familiar with. In the Canadian context, actually, it's much less present in the courts. Some of the examples in terms of the vulnerability contest I have in here. So old age alone is not sufficient to receive accommodation for vulnerability. A diagnosis of mental illness does not automatically lead to accommodation, although it may affect credibility. So those are some of the examples from the case law that one of my colleagues found out about. So there seems to be an interesting tension between what's going on at the European level and what's happening at the Canadian level. That's just a quick snapshot because I know I think, taking up a lot of time. Okay. The Europeans are also saying that, well, we should really think about vulnerability not as something where we're correcting an imbalance, where we're trying to bring somebody up to the same level, but it should actually be considered a positive obligation where we are really thinking about how we can assist somebody procedurally, but also substantively. And then so far in the research, it is clear that there are some people who are very often overlooked, but one group seems to stand out, and that seems to be refugee men, because there are some, especially young men, who are already targeted by security forces overseas. They might be targeted because of their sexual orientation, but then when they get assessed in the screening process, they're often not considered vulnerable. And that is something that's also reflected in some of the interviews that colleagues in Europe have been doing. Okay, I wanted to give you a little bit of an insight into what this research project is about, but I wanted to, I hope, leave some time for questions, because it's really a difficult thing to get your head wrapped around. If you were a decision maker, what you would codify, what you would allow the officer to have in terms of discretion, and then how would you operationalize this? Because there's so many different scenarios. So what really should this look like? And that's, of course, not taking into account situations that are humanitarian emergencies that we're seeing at the moment. So I'll stop, and then I don't know if I should stop screen sharing as well, or how would you like to do this?
I guess you can just keep. Well, no, yeah, stop the screen sharing, I guess. We can see the other folks. And then it'll be easier to see people who have questions. Okay, so, normally I would moderate the discussion, but given that it's easier just to have one person there, maybe you can just moderate yourself. Yeah.
And then the question is, can people hear you if you're asking a question? Okay.
Yeah. Okay. Yeah. So thanks very much. I'm still a little bit confused about the EMIC versus edict usage, the members' meetings versus some kind of analytical usage of vulnerability. It seems like if you're doing a comparative project, you need your own operationalized definition of what vulnerable is. And there's going to be a gap between that and how it's actually used by policymakers and NGOs and so on. So are you trying to do both? Do you have your own definition? This is what the team says vulnerability is for that edict purpose, as well as looking at how it's used chemically. And then, related to that, we just had a panel with the books by Rebecca Hamlin and Karen Akoka. And, they say there's no difference between the way that a refugee is categorized versus some other kind of migrant. That tells you something about the categorizer, not the categorized. I don't think that's actually entirely true, but they're onto something important there. But if it's hard enough to tell the difference between a refugee and another kind of migrant, how then can we make these distinctions among refugees?
So 2 questions that I'll repeat for the online audience. The first one was about whether the project has a definition of what we think vulnerability is, and then we're going to go out and discover what the bureaucrats and the migrants and the NGOs, what their definition of vulnerability is, or whether we just go and set out and find out what everybody thinks, and we don't have our own definition. The second question was about the distinction between refugee and migrant, and David was reminding us that there was a panel with Rebecca Hamlin, who I know, and the second author, I forget, about challenging the definition between refugee and migrant. And if it's hard to tell who's a refugee and who's a migrant, then how can we make these distinctions about who's vulnerable and who's not? And both are, of course, excellent questions. So to the first one, no, we don't have a preset definition of what vulnerability is in the team, because I think that's partially what motivated some of the team members was to find out what the definitions were that were floating about. And because I don't think many of the people have themselves a preset idea of what it should look like. Conceptually is also one thing, and then how you operationalize that concept is yet something else. So I think that doesn't help any. So I personally find it easier to learn what everybody thinks. And then, so this is the inductive versus deductive reasoning thing, but the project does not have its own definition. Otherwise, I would have told you in my slides, here's what we think, here's what they think. So it's very much about finding out what the government decision makers think, what NGOs think, what migrants think, and then seeing where the gap emerges, and then trying to be clear if we're making our own judgment calls. On the migrant versus refugee definition, yes, I think that comes out even more so with the Canadian team, because as I mentioned briefly, in Canadian legislation, the term vulnerability pops up in other contexts. For example, with seasonal agricultural workers, with victims of trafficking, who for some bizarre reason, and there are many people that have advocated that they should be able to apply for asylum. So I think I've also been one of the people who's, yes, who's also said that I find the asylum definition confining. But in the project, we keep coming back to this because it's a comparison with European partners. And I think they're not quite there yet. For them, I think asylum is where they locate vulnerability, and everything else, because of different histories of migration. Yeah, for me, there's kind of a lag in the conversation. So I think it is challenging, and I think there are now papers emerging also by European colleagues who talk about the colonial origins of the definition, the 1951 definition, But I think, again, at a policy level, the European colleagues haven't arrived at that moment yet where they can see that. But vulnerability is still a tool that I think people find helpful. And that's, I think, more what the interest is. But I think David is right that that might be a problem if you then just focus on refugees. But that's where everything gets tangled up. And then the question is, do we not do anything because we think everything is tangled up? And that's not, I think, the right decision, because this is happening already in the global context, in the global compact, that the commitment is there and policies are being made, even though there are these different understandings. I will stop there, and there are, oops, now did I click on the right thing to bring up the chat? Uh-oh, thought I'm doing this right. Warren, I don't know why the chat doesn't pop up. I think it's disappearing somewhere. Normally, if I click on there, the chat appears. Okay.
So
Maybe, yes, maybe one of the people who wrote something in the chat can unmute themselves and just see it, because for some reason I cannot see the chat appearing.
There's nothing on chat.
Yeah, there were a couple of, oh, somebody said thank you, and then I wasn't sure if there was a question as well. One of you Zoom people, do you have a question? This is your moment. Unmute yourself and ask now. Ah.
Yes, hi.
Hi.
Hello, this is Fernando Villegas, a doctoral student at UCLA. The question that I wrote in the chat is about the role of local governments and local legislators as well,
right,
in the design and implementation of refugee law and policies in Canada. So basically, is what has been the role of these local agents in Canada. You know about this debate between sanctuary cities, states in the US that have been present in the past years. So I would like to know what will be the role of these local agents, if possible. Thank you, Doctor.
It's a great question, Fernando, because you're getting at the different levels of decision makers, but also at the different levels at where services are provided. The decision makers could be at the local level when it comes to whether a child receives the right services in the school, for example. And since you're talking about sanctuary cities, whether a migrant who's undocumented receives healthcare. So they are definitely, I would say, also vulnerable. So that's where I think the local level is interesting, because that's also where we're getting to the conversation about discretion, because local officials, if you're standing in front of somebody and you're asking for something, this is where they then are on their little molehill and where they can just decide, okay, you just go ahead. And this is also where the American context, of course, is so interesting, because there's such a large population of undocumented peoples that are receiving services that in some other countries they might not be receiving. But in terms of the vulnerability conversation and what the local officials are able to do, I think that is where there's, again, the conversation about discretion is the interesting one. So, but in Canada, local officials, I think, are really important when it comes to integration, but as I just mentioned, schooling. So I think it's quite similar to the Canadian context, but at the local level, there's no decision-making happening about whether somebody can be formally accepted, because that still happens at the federal level or in the regularized process. Outside of asylum, you might be nominated by one of the Canadian provinces to come to Canada, and that's again not a refugee conversation. But in terms of vulnerability, I think local NGOs are hugely important because they can also provide integration and they can provide the services that somebody might need. So that's where the local level, I think, is much more important, is in actually helping people get settled and provide the information, especially now with COVID also, to provide the technology access and to tell people where to go. This is also where Canada's private sponsorship program is, of course, located at the local level, because the individuals, the people that have agreed to sponsor somebody and to help them if they have, healthcare needs or not, that's where the local level is critical. So it's a great question. I'm not sure if that answered what you were wondering about. That's the way it always is in these talks, but the local level is very important.
Thank you so much.
Any other questions from, oh, there's another.
You can ignore that chat. You can ignore that. That's Warren. Just
That's
telling people
Warren?
to raise their hand.
Okay. Any other questions from the virtual audience?
I had a question.
Hi, Brenda.
Hi, thank you so much for your talk. I really appreciate it very much. I wanted to ask you sort of like for you to comment or elaborate more on something that you brought up when you first started your presentation. You asked, can we even get policymakers to care about the theory of vulnerability? And I think that from my perspective, I always feel it's very important for researchers, us academic scholars, to be able to kind of demystify and move our research into policy, into practice, or at least, informing policymakers about our research finding. And so I guess I kind of wanted to know a little bit more about your experiences in doing that, maybe some of the challenges that you had, or even just like initially onboarding and starting those communications processes with some of the policymakers and legal scholars and things of that nature. I just wondered if you could expand on some of that.
It's a great question, because I think it's very much about their role. So some judges don't want to speculate because they don't want to, that's not their training, right, to speculate, but they can refer to jurisprudence that they're familiar with. We've interviewed, I'm thinking about somebody overseas who we interviewed who had started a PhD and was involved also on Twitter in refugee resettlement. And she was very much interested, I think, in some of the theoretical discussions. And she was also a manager. So she was also very interested in, because she was overseeing people who were making decisions. And there I found, again, the interest also in the conceptual conversations, but many of the lawyers and lower level decision makers who we interviewed so far, for them, it was often a struggle to get them to think about the theoretical stuff and to get them to be systematic about it. And they weren't then referring back to their training manual. That sometimes came up with the overseas people, that they were saying, well, we have training for this. And then we were asking for some of the manuals, but they weren't, their last training was in, one person said, oh, the last time I went to training was in 2012. But are they still keeping up to date, and can training take the place of what you're just asking? Because that is really also, and I'm hesitating because I'm thinking about somebody's research who's looked a lot at how we make credibility assessments in the asylum context. And I guess I wonder what our innate knee-jerk reaction about somebody is, and then what training then provides and does in that translation process that you're just talking about. But I think just getting people to reflect and to communicate with academics, and it's been hugely difficult in, I think, all of the projects to have these conversations, because governments are suspicious often of academics. But I think in the Canadian context, we had to sign agreements with certain parts of the government, and then they were then sending out a call for volunteers. So this is also where, of course, we don't know, the people that are already interested will be talking to us, right? So I don't know. Yeah, I'm just saying I don't know, because then there's that big void of all the people that didn't care, didn't want to talk to us. But I think to try to have that conversation is so important, because it allows people to stop in their day-to-day job and to think about am I still making the right decision? But that still takes somebody very thoughtful, and I can understand being completely overwhelmed, especially right now. So it's a difficult, I think, but very important translation process, as you said. And I keep staring at the big screen. I should be staring at the camera here. But thank you. Yes, it's a very, it'll be interesting to see, because we're going to have workshops with policymakers in the EU and in Canada, how the take-up of that is, and what the conversation will be like at that stage, I think. Any other questions? I have 2 hands up in the physical room. I'll repeat the question.
Okay, so you mentioned the legal theorists, so, and it's true. I was really interested in precisely that point you brought up, the innate markers versus situational markers. Because in my mind, so I'm having trouble, I suppose, understanding why they're even separate categories when it comes to defining who is vulnerable. Because in my mind, for now at least, one's innate markers, you know, depending on the situation one is in, will be exacerbated or not. So my question, I guess, is like, I know you said that you're gonna share with me some material, and please do. But could you give us a little bit of a preview as to what that kind of theoretical discussion is about, and why they kind of pitted against each other? And kind of related to that, it seems nonetheless that when you mentioned that, at least for overseas resettlement in Canada, they're considering this concept of urgency, which the way I understand the way you described it actually sides more with the situational marker type of approach. So is there already in this kind of again different situation where the law is kind of being made, is there already a bias coming out, at least for the Canadian government, as to which is more prioritized?
2 excellent questions. I have to make sure that I paraphrase them correctly. So the first question was about the theoretical legal theory discussion about vulnerability and the difference between the innate markers and the situational markers. And the second question was related to that because it was a comment on the overseas criteria in Canada that where there is this urgent category, where the comment was that the overseas, the urgency criteria, the fact that there has to be an immediate physical threat to the individual, that seems to be prioritizing the situational characteristics of vulnerability. And the question was whether there was already a bias that was apparent. I think the answer to the second question definitely is yes. It's interesting because it shows a different hierarchy than what some of the interviews are revealing, because that's where people often fall back to the innate characteristics. And to Brenda's point, this is where we're getting at what somebody thinks vulnerability is. They think of what you see in the media right now, women and children fleeing Ukraine and elderly women being helped across some barrier on some river in Ukraine. That's what comes out in the interviews, or somebody, I've seen pictures of somebody in a wheelchair with their family. So that is what one thinks about very often. But I think the theoretical consideration, so Martha Feynman is a legal theorist who seems to be very popular, and I'm saying seems to be because I'm in this project, and then I seem to enter this conversation about people who all were talking about one particular theorist, and I thought, oh wow. And so this is a feminist legal theorist who I was not previously familiar with because I was coming at it from a policy angle. But I think there is the trying to expand the world of vulnerability and to make it not just about innate markers, but to make the argument that the situation should be taken into account. So I think then there are people who criticize the situational circumstances and say, well, but I can't even summarize this properly because I always get lost in some of the details of what the pros and cons are. But I think that's in some level, that's normal academic debate that we say, well, but this has, these disadvantages and this part has these disadvantages. But for me, the more interesting part really is, well, does that lead to a disadvantage if you're actually the person who's seeking protection? And that's where you rightly pointed out, there's definitely a bias to the situation, but the situational characteristic is, my hands are drawing a little circle, it's the imminent physical threat, right? That gets you into the 7-day processing in the Canadian stream, in the immediate you need to get out category, right? And I'm sorry that I can't summarize some of the, because there's a really interesting article by a European colleague who's saying there should be something called migratory vulnerability, because again, this is the, oh, this is just normal that you're a woman from Haiti and that your entire country is a disaster and that you're constantly a threat of, you know, gender-based violence, but only certain kinds of women, and this is just an example from case law, who are from a certain economic group will be more threatened than other women. And that was the decision. And it was consistently the only Haitian women of lower class will be considered vulnerable. Everybody still could qualify as a refugee because of the gender-based violence, but only the women who were in the lower class were considered even more acutely vulnerable. I find this really, I think really difficult precisely for the reason that David raised in his earlier questions, is that I don't have an answer as to how we should organize this, but I'm just worried if policymaking proceeds without the moment of reflection and without the thinking about how it's already, for whatever historical reasons, in the various policy streams. So that's what I think I'm worried about, but I don't have the answer as to what my conceptual map would look like at the moment. And the graduate students, I think, very much struggle also with the situational versus innate characteristics, because there's so much talk about intersectionality and situational characteristics also being constructed by the state. And that's, I think, also what makes the conversation difficult. We have another audience member who's been patiently waiting, and maybe I've spent too much time answering this question because I feel like I'm not giving a good answer, but Joe, do you want to go ahead and ask your question?
Well, it's really interesting. There's so much weight on this term now. I mean, life or death, right? So one interesting thing that's coming to mind about the U.S.-Mexico border is the Title 42 and the migration protection protocols. The Biden administration has continued these policies to send people back to Mexico while they wait for their asylum claims. But now there's some more exceptions for vulnerable populations. And so defining those is really key. And I know that one of the more recent ones, other than unaccompanied children, are transgender or some LGBT migrants, which is, you know, more, I mean, it raises a lot of questions. How much more vulnerable is an LGBT migrant than a woman, than a man who's just is likely to be subject to kidnapping and extortion in this really awful context in northern Mexico. But some of those are considered like big wins by the advocacy communities. And so I'm just curious how you and the other researchers on this project are grappling with like having these conversations with decision makers who don't have the most nuanced perspective on things, need to establish categories that exclusively help some and eliminate others. And so when it helps some at the expense of not including others, because we can't call everybody vulnerable, how has that been received? It's just a very touchy, sensitive thing. And I can see how there's a potential where some decision makers might react and say, okay, well, yeah, everyone's, you know, there isn't that much gradient here in difference in vulnerability or rights. So we won't, you know, there's no regulations that need to be put in place to protect specific populations when advocates are saying these are very important, you know, strides to be made in these you know, exclusionary policies that are borders and asylum processes.
I will try to repeat some of what Joe just said, which was about the example of the Remain in Mexico policy that the Biden administration was continuing at the US-Mexico border, even though it was put in place by the Trump administration. So many of you will know that this means that you have to wait in Mexico for your asylum claim until you can actually cross into the United States. And he was pointing out that there are some exceptions now in the regulations under the Biden administration. that are singling out certain vulnerable groups. And again, you can put the quotation marks around it because his question was precisely about who had been selected and the reflection, the comment that he made. So one was transgender individuals, and the second group was
Unaccompanied minors. and
unaccompanied
some with
minors.
disabilities. I'm not sure what
Yeah.
the categories are now. But
Yeah,
it's
so
just
that
examples.
but that was an example for, I think, the bigger question is how the project has been dealing with the fact that NGOs consider the fact that some of these individuals can now proceed to the United States faster, a political win, because this is, of course, something where the policy is being punctured with exceptions, but how is the Vulner Project grappling with this? And I think in my interviews with Canadian NGO representatives, they don't like the term in the first place. And the fact that you have to create these exceptions, because they then often say, well, everybody, you should just craft a broader policy for bringing more people in. You shouldn't be focusing on this piecemeal selection thing. But that's, of course, we all would want a more inclusive immigration policy to start with. So I think this is a very difficult conversation, but I think the strategic person in me also thinks if you can open the door a crack wider and be more systematic about it, then maybe that's helpful. But Joe already said, well, I don't know if somebody who is a trans person waiting in Mexico would be more vulnerable compared to some young men who might be subject to extortion. So this is precisely also the question that the previous person asked about innate characteristics versus the situation and how much that matters. So I think, yes, it's important to have political wins always, but it's so hard to judge really what the unintended consequences are. It's the same with jurisprudence and my other work that deals very much with legal mobilization, because oftentimes if you take a case to court, you don't know what the consequences are, in particular if you don't win in court. But I think the advocacy community always says, let's go for it, because in this case, I'm sure, as you said, they're happy that there is at least a path, and then maybe that can be followed up with more challenges to the policy. But this was already a court decision, right? The Remain in Mexico policy. But yes, I think the struggle is something that we have not talked about in one of the team conversations in the Vulner Project, but we should, because we have these different audiences, because we also have migrants themselves, and the people that we've interviewed so far in Canada, they all really also want to make a difference, and they want their stories to be heard, and they want their examples to be used, so that the conversation between the NGOs and governments and themselves can be more equal. So I think that also is where the advocacy organizations come in, because they amplify the voice of the migrants. But yeah, this is again where I'm shaking my head, because that's the struggle, right? You don't want to make it worse, because that's the humanitarian, the poster child of, in Canada, there was the boy that washed on to the beach that many of you will be familiar with. He had a Canadian connection because his family had tried to come to Canada. So that was very much discussed and analyzed, but also in terms of creating change, that picture of the boy on the beach, that in terms of vulnerability really pulls on all the heartstrings. Emotion is so important in policy making. It at the same time, overusing it is also what is problematic. And that's, I think, also at the heart of vulnerability, is that you want that person to say, no, we cannot possibly leave those children in Mexico or in Ukraine or in Afghanistan, right? Because that strategically often makes the difference. But yeah, it's an excellent question, but I'm sorry, have a good answer for that, but we will, I hope, get to discuss that if we have some separate conversations where NGO leaders are also participating in some of the talks. I see chat comments.
Yeah, that was a thank you.
Oh, okay.
Yeah, so another question. What's really interesting about this to me is that Canada's first refugee resettlement programs after World War II, like the refugee resettlements and all the other major countries that we settled, were explicitly looking for refugees who were not vulnerable. They were, to use the phrase of the day, skimming the cream off the camps.
Yes.
And Canada was in a competition with the US to get, quote unquote, the best refugees before the other side did. So to hoover up, the engineers and the doctors and so forth. so what happened? How did we get from that situation where the refugee resettlement was designed to take refugees, but the least vulnerable refugees, to today where there are actual references written into both the UN handbook as well as Canadian law or regulations anyway, to select some of the most vulnerable? How do you explain that?
So David's question is a historical one, which is great because I like historical stuff. It's about the beginning of the resettlement programs for refugees after World War II, where Canada, and I don't know about the US, maybe the US as well, but Canada was accused of taking the cream of the crop of the refugees and wanting the ones that could have easily made it under some regular immigration program that after World War II probably didn't quite exist. But for a very long time, Canada has had the, you must show evidence that you can successfully resettle in Canada. And that is still on the books, that requirement. So in terms of the what happened question, you must show that you can successfully resettle, again, putting my quotation marks in here. It's still there in the regulations, but it's supposedly not applied anymore. So there's a colleague, Shauna Lobman, who's written a really interesting book, if you're interested, and she has also done a lot of work on the resettlement side. And her argument is that it's there, but it's not used. But the question then that David said is what happened from this? We're skimming the cream of the crop off to now there's a focus on vulnerability. I think if we look at the quantitative numbers of who still gets in as the cream of the crop, that's still happening. But the critics in the resettlement world say that that's now happening in Canada in the private sponsorship stream, because that's where people come to Canada who already have family members and who don't have vulnerability. And the government is increasingly, if you look at the numbers for resettlement, preferencing private sponsorships because it plays well in the media, it gets community buy-in, and it's cheaper for the government. So the advocates are saying, that's great, but will a church or a so-called group of five really take somebody who has these high medical needs? There isn't a lot of data or evidence of that, but it's not so likely because it will be harder for them to resettle. So I think quantitatively speaking, I think we're still doing some of that if you look at the numbers, because if you look at the US and the Canada handbook, then you see how small the numbers are. For example, for women at risk, it's a few hundred, and Canada also takes like, well, 25,000 was the big promise to take 25,000 Syrian refugees, and then more people actually came because they're family members. But that was a big number for Canada to resettle in the Syrian context. But again, in terms of how many women at risk were resettled, they get profiled. And there were Yazidi women that got profiled in the government report, but there were a few hundred. So again, in terms of vulnerability, maybe it's also, I don't know, to make up for some of the securitization, to emphasize Canada's emphasis of historic commitment to refugees and to resettlement. Maybe there's a partisan tinge to this, but I think quantitatively speaking, the answer is we're still taking the best ones, because probably the most vulnerable people, they don't even get close to even being selected for resettlement, because you have to be assertive in the community, in the camp, you have to present yourself, you have to register with UNHCR, you have to even get to those contexts, you have to make it maybe to the US officials, and you have to then out yourself as, I don't know, whatever your markers are. So I don't know. It's something to think about, whether that is really an overall shift or just a PR exercise. I guess I worry about that.
I've used the fact that I'm here across the middle, any other questions. One of the questions, picking up on what you just said about PR.
Private sponsorship, yeah.
Well, just the idea of the publicity function. The publicity function of this.
Something is beeping, but I think it's just the backwards. Yeah.
Which is that there are at least some cases where a government will not take any refugees, but they will take people who've been injured in war, provide them with medical care. Publicly talk about that as an expressive function of foreign policy. So I'm thinking, for example, of the Israeli government's posture towards some children in Syria who've been severely injured, in the war who've been allowed to come to Israel for medical treatment, and it's been a big deal in the news, but no refugees would ever be allowed to come and settle, certainly in any numbers, right? And so I suspect that there are other issues around the world where it's not simply that this vulnerability question is a subset of refugee as immigration policy, but really does obey a completely separate logic.
So the comment is about the public relations logic of picking certain humanitarian, I guess I have a hard time paraphrasing this because you're emphasizing that it's not just about immigration and refugees, but there are certain migrants that we can pick out and profile them. And David's example was an Israeli example about children. They were, what was the detail?
But children who have been injured in the civil war in Syria and then brought to Israel.
Oh, children who had been injured in the civil war and then were brought to Israel, but they were not granted status. They were just treated. Right, so the PR function of doing this, still appealing to the humanitarian image. I think there is a humanitarian beast out there that needs to be fed in all the different countries, depending on what your overall image is. And Canada has had that. We're the humanitarian leader image. Israel is an interesting one because currently the government maybe want to have that image a little bit more than before. So yes, I think this actually gets at the question about what characteristics get preference, but also an agency and what appeals to our inner senses. So yes, if it's used to pacify, to say that we've done our bit, but it's the same as Turkey not being a member of the 1951 convention saying, well, we've done our bit now, everybody else can please offer resettlement spots, so that it has the domestic audience. If the domestic audience is pacified with the we've done our bit, but now everybody else, I think that's in Canada, there is public opinion that is still strongly supportive of bringing refugees to Canada. Even after COVID, there was an interesting poll that actually support went up rather than down. And yes, I think there is public support, but it's also about that long historical image. And that's why, of course, the US case is interesting because US obviously has had that long commitment to resettlement. And that's also been, I think, not necessarily prioritizing vulnerability, although when I was looking at the US details, there's also priority 1 and priority 2, and that seems to, I was just beginning to read up on that. There is also a pecking order that is, I would say, about vulnerability, but you probably know more about that. So yes, it definitely gets used all the time, right? And humanitarian scholars who work on development aid probably know much more about that than we do. It satisfies certain something in the public image of a country.
Well, we are probably, we're probably a little bit past time, but I want to thank you for sharing the project, and I'm sure people will be in touch with you offline and privately with other comments. It's a really interesting question, truly. So
yes, and it's fascinating to present when you don't have all the answers yourself. So it's really
a more useful time.
Yes, that's what I think is actually the best when you're presenting, when you're really interested in what other people have to say, rather than presenting something where you're like, oh, I just published this and here is, please read. But of course, if you're interested, please read. I'm happy to also share the website and all this kind of stuff. So if you're interested in the project, please get in touch.
Okay,
Thank you
very much.